A stage 4 pressure injury, or for lack of a better word, a big gaping hole in your body, can be very painful. The question is, how do you convey that pain to the jury? I'm attorney Rob Schenk. This is the Justice for Residents podcast, and this week we welcome Matthew Heimlich, a Chicago nursing home lawyer who has obtained numerous 6- and 7-figure results in pressure injury cases, and we're talking about the evidence that demonstrates pain, how to find it, and why some jurors get it while others don't. Stick around. Well, that was certainly a rockin' jingle. Welcome back to the Justice for Residents podcast. Awesome conversation with Matthew Heimlich. But your homework is going to be to go back and listen to episode 205, where we talk about comorbidities, unavoidability, and the underlying medicine, for lack of a better word, in pressure injury cases. And we did that with Andrew King, attorney Andrew King. And then I would say there's a couple of episodes that I would check out again with on the medicine side of pressure injury cases. Both of those were with guest Martha Kelso, who is a wound expert. That's episode 138, which was what prevents pressure injuries from healing. And then 135, which was understanding the pressure injury stages, like what are the characteristics that we look at when figuring out if a wound has progressed from one stage to the other. So that's your homework. Episode 205, which came out in 2024, and then 138 and 135, which both came out in, I guess, the beginning of 2020, end of 2019. That's your homework. Now we're going to get into the ribeye and fingerling potatoes of the episode. Matthew Heimlich is a partner at Malman Law in Chicago. His practice focuses primarily on representing residents and their families in nursing home and assisted living negligence cases throughout Illinois. He has achieved numerous 6- and 7-figure results in cases involving pressure injuries, including a $1.1 million verdict for a hospital-acquired pressure injury. We're happy to have this conversation with Matthew. Matthew, can you just run through some of the more typical negative outcomes from a pressure injury?
Yeah, pressure injuries are really kind of insidious. They really can end up having a whole host of effects on the resident. That it's more than, even just the wound that you end up seeing. I mean, the first most obvious thing is the skin breakdown and the tissue destruction. Even if it's just that, even if it heals, this resident now has a permanent loss of skin integrity to that area. So their skin is never going to be the same. It's more susceptible to future breakdown. And it is that in and of itself can and will be a permanent injury. The big thing with wounds is obviously the concern is for infection. The nursing home is supposed to keep those areas clean and dry, do dressing changes, do incontinence care if the resident's incontinent. And the whole goal is to keep that wound free from becoming infected, because infections, particularly in older adults who are otherwise, a lot of them are immunocompromised, a lot of them are malnourished, is that can turn into sepsis, and sepsis can and does is fatal in many cases. So infection control, infection prevention, those are essential things, and those are things that you're always worried about when someone has a pressure ulcer. And some of the worst infections, if the wound is deep enough, if you got a stage 3 or a stage 4 type pressure ulcer in particular, is that you're worried about a bone infection. The medical term is osteomyelitis, and that in turn can cause sepsis, that can get systemic, that can lead to even a bone. They actually remove part of the bone sometimes if it becomes infection. It become very invasive, very painful. And sometimes to correct the defect caused by the wound, they're going to do, first of all, they're going to do surgical debridement sometimes, which is literally scraping the dead tissue out of the wound with the idea of getting it clean, so they can kind of grow some new healthy skin tissue where the wound was. Sometimes they also have to do a flap surgery to close a wound that is unable to close on its own. So that's kind of a plastic surgery type procedure where they take healthy skin from elsewhere on the body and cover the wound to kind of A, insulate it from becoming recurrently infected, and B, kind of, promote that skin growth and skin healing. Depending on the nature and location of the wound. Sometimes, if a wound is chronically or recurrently infected, it can lead to amputation. This is particularly prevalent in situations with ulcers or pressure ulcers on someone's heels. They're unable to be resolved or healed. They become recurrently infected. The concern is that the person may go septic, and they decide that unfortunately, in some cases, the best option is to have an amputation to protect the rest of the body and the resident's health as much as they can. It also it can be caused by and contribute to both malnutrition and weight loss. When the body's trying to heal a wound, it kind of allocates a disproportionate amount of its resources to this open area to attempt to heal it as best it can. And that ends up depriving the rest of the body of the resources that it needs. And, the person can become malnourished. You can see weight loss. It also contributes to kind of a more overall functional decline for those same type of reasons. The body's using a lot of energy to try to heal the wound. The person's going to not have as much to be mobile as they would have before, and it's kind of a vicious cycle. Another thing we end up seeing with wounds, particularly in the sacral area, which is one of the most common areas for wounds to develop, on the resident's backside, is if they're incontinent, they need to be catheterized to keep, and that's with the idea of keeping that wound clean, dry, and free from infection. But that kind of creates its own set of complications because catheters often become recurrently infected. They can lead to lots of UTIs, which have their own set of problems. They can cause delirium, can cause infection, can cause sepsis on themselves. So it's kind of a catch-22 for the residents, and that it all starts with these wounds. So they can cause a whole host of problems for the resident, and even the treatments can be problematic in and of themselves.
Well, with respect to let's isolate the pain from having an open hole in your body. Okay, is there any particular way that you convey that to the jury? Like sometimes it's not self-evident. Sometimes you get jurors like, like, well, I've gave birth. Like, I mean, that size of a nickel hole in your body, that's nothing. Like, how are you conveying the concept of pain to the jury?
Yeah. Pressure ulcers, especially, depends on the severity and the location. They can be viscerally very shocking. You and I have handled many cases involving pressure ulcers, and we've seen how bad they can get. The average person has no idea. And, you show a photo of a wound to someone on the jury panel, and, you get a lot of gasps. You get a lot of people who didn't know that this type of thing can happen to somebody if they haven't had, the experience of working in a healthcare facility or a nursing home. This is not something that's commonly known. So the photos, if you have them of the resident, of the wound, are something that, can be really, really powerful evidence and can really resonate with the jury. I would caution that you don't want to overuse the photos, especially if you have a lengthy trial. If you just have a blow up of the photo and you leave it behind you while you're, putting on your case, the jury's going to see it every day. And it's only human nature. They're going to become kind of inoculated to the effect of it. So what initially becomes, a gasping moment just becomes, oh, this is something that happens to people when they get older. And obviously that's not the case.
To that end, are you typically, is this something, if you have an image and it's shocking, is this something that you show an opening and then do you bring it back maybe during your expert examination or during closing?
Yeah, that's actually the last pressure ulcer case I had. That's exactly what we did. It was very brief during opening, just kind of gets the jury's attention. They're just like, wow, that's something. That's I see why we're here now.
Mm-hmm.
And you put it on with your expert because you want them, the expert, to explain if these failures in care, they lead to this horrible outcome, and just kind of a reminder of why we're here. And then, at closing, you want to, again, just very briefly, just to remind them, the full extent of how bad things got. But you certainly don't want to bring it up all the time. The defense may want to bring it up, honestly, more than you do. Because after a while, you start looking at this for days on end, and it doesn't seem it seems like something that it's not. It seems like a part of the end of life process,
Right.
and it certainly doesn't have to be. And it certainly, and I think even the most hardened defense experts would agree that most of these are avoidable.
I think that I had it was Don Smith, attorney Don Smith. I can't remember. I think she's out of Arizona. I probably got that wrong. But she talked about how at some point she would in depositions she would ask like the DON or the nurses, have you ever seen a pressure injury? Have you ever seen a stage 4 pressure injury? How does the resident take it? And they're like, no, it's painful, like, et cetera. Do you ever try to elicit the pain testimony, not from the family, but perhaps from the nursing home staff themselves?
Absolutely, and that can be the best testimony if you give. Yeah, and a lot of the people who work on the ground floor of these nursing homes are very, they're hardworking, they're very empathetic. They get into working at these facilities for the right reasons. And if you ask them honest questions in a fair way, a lot of times they will give you, they'll give you an honest answer that can be very powerful when presenting the case to a jury. A lot of things you want to go through with them. They include your rules about the frequency and documentation of pain assessments. You want to go through the pressure ulcer assessments and talk about, this is pain. This is painful. You want to talk about the like for dressing changes. A lot of times they give pain medication before the dressing change. Well, why do you do that? Oh, it's because the dressing changes are painful.
Oh, that's
Let's talk about, we have a wound vac. What is a wound vac? How does it work? Well, it's this suctioning device that we place on someone's, the location of someone's wound on their heel or on their backside. And it's designed to, keep a clean, dry, area and prevent the wound from becoming infected. Well, how does it sucking? So it's literally physically sucking on the resident's back or heel all day. Yes. Is that something that can be painful? Oh, absolutely. It sure can. We often give pain medication for that. And you can go through that with the surgical debridements. Same thing. They're literally getting in there and cutting dead tissue out of a wound bed. I mean, with knives and surgical instruments. I mean, it's, even the enzymatic debriding agents. It's like, oh, you're putting this, really kind of intense medicine in the wound bed that's literally like it's cleaning out and it's getting rid of all this dead tissue chemically. Yes, that's exactly what it does. So, I mean, a lot of this stuff, if you just break it down and have the staff explain what it is, how it works, even if they won't explicitly talk about the pain with your particular resident, I mean, the jury's going to get it. These are
yeah,
not, these are painful things. It's not just someone has a wound and that's it. It's like, no, they have a wound, and even the treatments are painful. Not
yeah.
just the wound in and of itself. The treatments are painful too.
Right. I guess you make it easily inferable. The pain is easily inferred from what you have elicited from the defense. So
Right. And it's a thing where, the pain is unavoidable too. The resident, there's certain things that the residents have to do and that the staff has to do for the residents that are going to be painful. At some point the resident's going to be, if they have a sacral wound, they're going to be on their back at some point.
mm,
They have to sit up to eat. If they're trying to do therapy, they got to sit up to try to do therapy. So they're going to be on their back. So they're going to be putting their body weight on an open wound. That's painful. Incontinence care, that has to be done. That's painful. Dressing changes, painful. Getting transported, painful. And it's unavoidable. So the staff has to do this stuff, and it all becomes part of this resident's life. And it's just kind of going from one painful activity to another. And it really adds up.
we interrupt this interview to bring you the nursing home regulation question of the week. This week, folks, it is medium difficulty. So if you get this right, and today is your going to the gym day, then going to the gym means literally going to the gym, sitting in the parking lot, maybe listening to this podcast for a few minutes and leaving. Like you went there. I mean, nobody has to infer that you actually went in and did anything. So going to the gym is literally just going to the gym, sitting in the parking lot and leaving. If you want to, if you get it right. Under 42 CFR 483.25N, bed rails used must A, be only half or quarter size, B, be installed only on one side, or C, be installed as per manufacturer's recommendations? And that answer is C. If you're going to have bed rails in a nursing home under the federal regulations, then they must be installed as per manufacturer's specs. Tell me about how you approach this concept that you're building this evidentiary house. How does that work when your resident, when your client is cognitively impaired or nonverbal? Like, how do we know what they're thinking?
Yeah, and that's one of the toughest and most tragic situations, and when you have someone with a significant amount of cognitive impairment who gets a wound, because it's not, they don't necessarily don't experience the pain, they just can't express themselves in the way that you or I can verbally or otherwise. So it makes, I mean, honestly, it makes the whole thing worse. There are scales and methods to attempt to determine whether or not someone who is has Alzheimer's or some other form of dementia and may not be able to verbalize their pain, to determine whether or not they are in fact experiencing pain. There's a scale that's utilized or should be utilized in nursing homes called the Pain AD scale. It's literally a specialized assessment for residents with advanced dementia, and it looks to a number of things to determine whether or not the resident's in pain. They look to the resident's breathing patterns. Do they have labored breathing? Are they hyperventilating? They look to frequency and duration of that. The other category is called negative vocalization. Basically, are they moaning or groaning? Are they calling out? Are they crying? All of those things are indicative that yes, this resident is in fact, experiencing pain. Facial expressions. Are they smiling? Are they sad? Are they grimacing? Are they frowning? All those things can indicate pain in a resident with dementia. Body language. Are they relaxed or are they tense? Are they fidgeting? Are they rigid? Are they pushing or pulling away or striking out? All of that can be, evidence of pain. And then whether or not, you're able to console them. Are they distracted or reassured, or are they inconsolable? So those can all be evidence of pain. And then, if you take all that into account, you can kind of paint a picture. Yes, although this resident can't verbalize exactly what's going on with them, they're checking all these boxes that indicate that they're experiencing pain. And especially if the pressure ulcer tends to be the most likely source of that pain, that's a connection that your experts can draw, that your family can draw, and that you can relate to the jury.
Any pushback from the nursing home, or maybe even potential jurors that you would need to kind of understand and voir dire about anybody that's made it to 85 years and older? Life is pain. Like, you're waking up with pain. What's the difference, right? Like, do you ever have to deal with that at the beginning, like in voir dire? Do you address this issue?
Oh, you have to. You got to get you got to get an understanding of who out there, just kind of is going to take a look at your case and say, this is just this is natural. This is the aging process. This is what happens when you reach a certain age. And those people are out there. It's tough. A lot of people are very tough. We've had cases where someone experiences a a loss of a parent at a young age, and you have a resident who's 85, and they go, my mom only, she died at 60. They should be thankful for the 25 years they got that I didn't. So you got to sort that all out in openings in voir dire as much as you can, especially if your courts will allow for it, and try to get them to state affirmatively that, yeah, I don't think I could, even if I hear testimony that the wound was avoidable. Even if I hear testimony that the pain and suffering they experienced was unnecessary, I don't believe that personally, and therefore I can't imagine myself finding on behalf of your client. And that's something that, if you're able to, I know the rules for voir dire and jury selection vary wildly, jurisdiction to jurisdiction. But in Illinois, where I practice, we are usually, not always, but especially in state court, usually given a pretty decent amount of leeway to ask those kinds of questions, and figure out where people's heads are at before the case even begins, to see if they'd be, come in with a bias that can't be overcome.
So I guess, is it the case then that it wouldn't be a case if it heals?
I actually had a case, it was relatively recent. I think we resolved it about a year ago, and involved she was supposed to be a short-term nursing home patient, and she had an acute illness, ended up in the hospital, was transferred to the nursing home, and developed a inexplicably large and horrible stage 4 bed sore that got recurrently infected over the next, I would say, 4 to 6 months. But then she went home, and through a lot of family help and home health aides and, going to an outpatient wound clinic, the wound basically healed entirely, and she was relatively fine going forward. And I managed to get a very substantial result for her, because a lot of the times with wounds in particular, the defense is usually a medical unavoidability type defense. Oh, this person was acutely ill. They were end of life. They were, they were sick. They were dying. Whatever the situation is, they're going to point and say this was clinically unavoidable. And they had none of those defenses here, because she was not particularly old. She was not end of life by any means. She was, in fact, very, when we did her deposition, I mean, she was very upbeat and chipper, very with it, very, very cognitively intact. So that helped on several levels. First of all, the wound healed. You can't say it's unavoidable when it's healed.
Right.
Second of all, she was very cognitively aware of what was going on with her. It was all very painful, very traumatic. And she also had a wonderful family, all of that helped, who were very, very involved. And all of that kind of created a circumstance where, the defense, eventually, I guess through settlement, we'll call it, acknowledged the extent of the harm that was caused, and paid a substantial amount, even though the wound was totally healed, and she was more or less as she was before all this occurred, by the time the settlement came through. So I understand where you're coming from, and it's most of that's mostly how I feel about the cases is similar. But I do really like when wounds heal, especially after they got really bad, because they really can't. There's no way a jury, in my opinion, would believe that they're unavoidable when they're actually healed.
Well, Matthew, really appreciate you coming on the show and sharing your knowledge with us today.
I appreciate it. Thanks for having me back on. Happy to talk with you anytime, on or offline, about this stuff.
Awesome. Well, folks, I hope that you found this conversation with Matthew educational. If you enjoy the Justice for Residents podcast, then I highly recommend, and not recommend, I would love it. Your call to action is to subscribe to this podcast wherever you get it. If you're on YouTube, please like and subscribe there. Leave a comment. That helps the algorithm. If you have an idea for someone you want me to talk to, let me know. If you have an idea for something you want me to talk about, let me know that as well. If you do comment on the YouTubes, you got to give me a minute. I don't get a notification immediately. Like, I just stumble upon them. So like, if I haven't responded in a day or two, don't give up. I will get to it eventually. New episodes of the Justice for Resident podcast come out every Monday. And with that, folks, we'll see you next time. Thanks for tuning in to the Justice for Residents podcast. Nothing said on this podcast, either by the host or the guest, should be construed as legal or medical advice, nor is intended to create an attorney-client relationship between the listener and either the host or any guest. New episodes are published every Monday and are available on all your favorite podcast apps, as well as on YouTube and our website, justiceforresidents.com. Again, that's justiceforresidents.com. The Justice for Residents podcast is hosted by Rob Schenk, a trial lawyer representing victims of nursing home abuse and neglect throughout the state of Georgia. We'll see you next Monday.